Good evening, colleagues. Pt.3 na legislature Guam is back from recess. Colleagues, we are now on item 15, bill number 377-35 COR. Minority Leader, you are recognized at this time.
Sijus Mase, Madam Speaker. I would like to make a motion to place Bill 377-35 COR as amended by the Committee on Government Operations, Appropriation, and Housing, introduced by myself, Senator James Moylan, and Senator Joe S. San Augustine, to the third reading file with the opportunity to speak on this measure.
Can you please read the title, ma'am?
Oh, yes. Okay. Thank you, Madam Speaker. This is an act to amend 30107 of Article 1, Chapter 30, Division 3, Title 5, Guam Code Annotated, relative to the timely issuance of opinions requested by the Office of the Attorney General of Guam.
On that motion, please proceed.
Thank you, Madam Speaker, and for the opportunity to provide a summary of Bill 377-35 as amended by the Committee on General Government Operations and Appropriations and Housing. I'd like to thank the Office of the Attorney General of Guam, the Legislative's Legal Bureau, and Senator Joe San Augustine and his team for working closely with me since November 9, 2020 during the public hearing, and to prepare the bill as amended for this month's session. Madam Speaker, as I shared during the public hearing, Bill 3.3 is similar to a proposal I authored earlier this term relative to timelines and administrative penalties concerning land use applications that are submitted to the Application Review Committee of the Guam Land Use Commission. Bill 377 is yet another measure that I've put forward to help close operational gaps. Section 3017 of Title 5 Guam Code Annotated requires the Attorney General, when requested, to give without fees his opinion to the legislature or members thereof regarding matters relating to enactment laws of the statutes of case law on a given subject. As senators, we are responsible for passing bills. In doing so, we must do our due diligence to ensure that any legislation before us does not conflict with enacted laws. Madam Speaker, in addition to the public hearing on Bill 377, which was held on November 9th, I had a follow-up meeting on November 13th, 2020, with participants including Chairman San Augustine and Assistant AG Stephanie Mendiola. Madam Speaker, with the recommendations provided during the public hearing and our follow-up discussions on Bill 377 as amended, which requires that there were recommendations on the follow-up. And some of them requires that a request by the legislature for an opinion from the Attorney General must be made by both the Speaker and the Minority Leader. Another one was, once a request is made, the Attorney General has 7 working days to provide an opinion, but this time period may be extended by an additional 3 working days, and the proposed personal daily fine of $100 will be waived. If the Attorney General requests for an extension and explains in writing to the Speaker and Minority Leader the reason for this delay. Another section was requests that are made by individual members of the legislature must certify that the question was presented to legal counsel, legislative legal counsel, and that further legal analysis and discussion is being sought from the Attorney General independent of the legal counsel. Another area of the bill is the AG must provide an opinion to the requesting senator no later than 30 calendar days after receiving the senator's request. And a member who wishes to allow the Attorney General additional time may decline submitting his or her request for an opinion from the Attorney General pursuant to the requirements proposed in Bill 377. Madam Speaker, according to the Office of the Attorney General, 3 jurisdictions, Texas, Montana, and Tennessee, address statutory timelines for issuing opinions requested by the Legislative House and not individual members. with most timelines in other jurisdictions based on internal guidelines. And I quote, "In Texas, where opinions can only be requested by a legislative House committee and not individual members, the deadline is 180 days from the request date with allowance for later submission upon written notice and justification. In Montana, opinions are due 3 months from request with allowance for later submission upon determination that the question is complex enough to justify additional time. In Tennessee, the law calls for issuance and as expeditiously as possible, but not a date certain." Madam Speaker, for the record, Guam law, as currently written, does not establish a timeline for the Attorney General's office to provide an opinion, which is in the case of requests made by members of the legislature, could actually mean weeks, if not months, before an opinion is provided. As I shared during the public hearing on Bill 377, whether a request for an opinion concerns the governor's authority to utilize excess general revenue or DOA's personal rules and regulations on double pay, the timely issuance of an opinion from an Attorney General's office has a huge impact on the local government, particularly the crafting of public policy and the use of limited taxpayer funds. In fact, in most departments, this is why these agencies really rather have their own attorney, simply because of these issues of time. Madam Speaker, we met with Stephanie Mendioli, the Assistant Attorney General, and she also provided an email to all my colleagues to review. But the intent, and as I mentioned during the conversation, and it's unfortunate that my colleague's not here today because he was part of this discussion and the back and forth, the convincing. One of them was the fine placed on the Attorney General. I mean, we were asking almost for $1,000, but we compromised to $100. There was even a time we discussed that it would be like 4 months, but we came to the understanding that 30 days with an extension would suffice as well. Once again, Madam Speaker, I humbly ask, that my colleagues consider Bill 377 that was amended and ask for their support and truly maintain the intent of this legislation, which is to provide a timely response by the Attorney General's office so that we senators can continue to do our job. Thank you, Madam Speaker.
Thank you, Minority Leader. On that motion, Legislative Secretary, can you take the podium?
On the main motion, is there anyone wishing to speak? Speaker, you're recognized.
Situus Masi, Madam Speaker, if I may, I do have an amendment, and I know that it should be uploaded with the clerk. And if I may, I'll just say it's AB 377 TRMB-MCT.
Yes, please proceed.
Okay, I proffered this amendment, Madam Speaker, and I understand that sometimes we get impatient when we are waiting for an Attorney General's opinion. I know I have written requests and followed up on them, and sometimes it just takes a while. And while we can allow our frustrations to dictate the policies we draft, and we all agree that as a government, we must do better. We must be cognizant that the Office of the Attorney General deals with a variety of issues, and we all know that there is a significant backlog in the cases that go to court. We all know that the Office of the Attorney General faces the same budget constraints that we all face. And I want to note that across 56 U.S. jurisdictions, most timelines for the issuance of AG's opinions are based on internal guidelines. 3 jurisdictions address statutory timelines for issuing opinions requested by legislatures. In Texas, where opinions can only be requested by a legislative House committee and not individual members, the deadline is 180 days from the request date, with allowance for a later submission upon written notice and justification. In Montana, opinions are due 3 months from the request, with allowances for later submission upon determination that the question is complex enough to justify additional time. In Tennessee, the law calls for issuance as expeditiously as possible, not by a date certain. In fiscal year 2019, the Office of the Attorney General received 220 requests for legal opinions or information based on their testimony at the hearing. A good percentage of them is from this August branch. Their solicitors division, who responds to these, have 12 to 14 attorneys, as I'm told, and 5 of them are assigned to a specific agency. Here in this body, I want to note, Madam Speaker, that we have 40-plus research and policy analysts, and look at the progress of this body. I want to share that we're still working on bills from last year. We introduced bills, and simply putting together a committee report sometimes takes up to a year, if not more, after introduction. And if we expect the Attorney General to be held to the standard, which I think is not realistic, the least we can do is give them the tools and resources they need to make this happen. And I agree that I would like responses within 7 to 10 days, but not at the cost of criminal cases being set aside, so that it's an all-hands-on-deck operation from them to do the research of a senator. And we need to look at policy making from a broader perspective, and that is why, based on my personal research, I'm proposing this amendment, Madam Speaker. And I want to note that based on this amendment, I am restoring Section A of Section 30107 of Article 1, Chapter 30, Division 3, Title 5, a Guam Code annotated as it is in the current law. The double underline, Madam Speaker, only shows for my colleagues the restoration of the original language. And then I am adding Section B, which would mandate the AG provide an opinion within 180 days or pay a fine, $100 fine. For me, Madam Speaker, I want to share that I think this is a compromise which I hope would satisfy the author's concerns and also the reasonable concern of the Attorney General. I hope my colleagues can help support this measure, and I would like, I know the good author of the bill had spoke that there was a letter and email sent to all our colleagues, Madam Speaker, but if I may, I would like to just read it, if you allow me. Affidavit, Senators, we understand that Bill number 377 regarding the issuance of an AG opinion is on the session agenda and has been reported out of committee in an amended version. While we appreciate the efforts of the sponsor and the committee to address some of the concerns raised at the public hearing, we maintain our opposition to the measure in its amended version. We reiterate, as we did in the public hearing, that deadlines on AG opinions are generally impractical and across jurisdictions are handled internally, not adopted by statute. If this body should decide to impose a deadline on the issuance of opinions, despite this impracticality, we ask that Guam be given at least the same consideration as the very few AG's offices across the country where such a requirement is imposed. As stated in our public hearing testimony, 3 jurisdictions that set deadlines for AG opinions do so as follows: 180 days, 90 days, and as expeditiously as possible with no number of days. The amended bill proposes to create 2 types of opinion requests: an urgent request on behalf of the body and a request from an individual member. The urgent request would be due in 7 business days with an extension of 3. The individual request would be due in 30 days. Both deadlines remain impractical, despite the proposed additional requirement that a senator indicate to the Office of the Attorney General that the legal bureau has also been solicited. Unless the requesting party provides our office with an initial analysis, as the other Gulf of Guam entities do, it does not speed up the opinion drafting process. Significantly, in recognition of the varying circumstances under which opinions are issues, the 2 jurisdictions that impose deadlines on issuance of opinions also allow for an AG's office to justify why an opinion may be submitted past the deadline. Bill 377 as amended offers a 3-day extension for urgent opinions and no option for justifying an extension for requests submitted by individual members. Finally, the amended bill proposes to implement a $100 fine. If a fine is to be imposed at all, we ask that it be reasonable and that the same consideration be given as the fine for failure to publish an opinion, $100 per opinion and not per day. And it's Undunkaluna Situas Masi for your time and consideration. Regards, see Stephanie E. Mendiola, General Counsel, Deputy Attorney General and Division of General Counsel. Madam Speaker, I think and I hope that my colleagues support the efforts. As I know the good senator from Santa Rita and myself looked at this option and looked for some way that we can strike a balance or some parity, and this is a way that we can do it. So I hope that my colleagues support the efforts, and I'm open to see their concerns on this amendment.
Thank you very much, Speaker. Anyone on the amendment? Senator Pt.3, you're recognized.
Madam Speaker. And, I thank my colleagues for them taking the time actually to look at this. And as I mentioned, the whole intent of this legislation was to provide a timely response from the Attorney General to the senators. Also, it was mentioned earlier that, that they taking away time for legal opinion for criminal issues. Well, legal opinion doesn't come from the criminal division of the Attorney General's office. It usually comes from the solicitor or the civil division, but it doesn't come from the criminal division when it comes to opinions. But again, Madam Speaker, I can't reiterate how frustrating, yes, very frustrating. We have a responsibility in this legislature. And it's to the people of Guam. And all bills that are coming out from this body, it's important that we seek legal guidance, not only from our legal counsel here, but also with the Attorney General's office. Waiting 6 months for an answer. If you look at the other jurisdictions, their population is 3 times the amount that Guam's population is. In fact, one of the co-sponsors mentioned that during the public hearing. These areas have, close to 1 million in their area, their districts of people, so it will take them longer. We don't have that large of a population. 6 months is way too long. So I have to object to this amendment, but I do appreciate the work they've done to look into this and try to make a win-win. But the win-win would be for the people of Guam and to get an answer right away from the Attorney General so that we can put up good legislation for this people to follow. Thank you.
Thank you very much, Senator Titlegy. There's been an objection, and I believe Senator Torres, you had your hand up? And followed by Senator Terlahi.
Thank you, Madam Speaker. I rise in support of this. I think because when you consider the testimony provided by the Attorney General's office, which is contained in the committee report, they discuss how they respectfully express their opposition because the deadlines proposed by Bill 377 are impractical. And they went on to talk about, how it is necessary to be, that their process is crucial to ensuring quality and value of written opinions and all that. And then I think another thing too is they discuss the unethical ramifications of the funds going to the Ethics Commission. But I think more than anything, if we consider what they're obligated to do as a legal branch and putting the time and effort to prepare opinions, they discuss how the extremely short deadline and fine proposed would risk the need for their office to set aside other urgent matters that may not result in personal financial penalties, but may result in detrimental effects to the legal and financial positioning of the government if other deadlines are missed, like procurement, contract review, or court filings. And so I just want to, bring their discussion about the practical problems of these types of deadlines to mind, because we all know that the law is methodical and often slow, and it requires careful and responsible evaluation, researching, and writing. So to rush things is never it is never a recommended course in the legal profession. And I think they allude to that in their discussions and their caution to the body. So, with that, just reading their testimony, I think that puts into perspective what the real challenges would be to them and how it can have an adverse effect on what they do and also their obligation to service. So I would stand in support of this amendment. I think that it's a good way to address their concerns, but still have parameters for the request of information and the expected receipt of opinions from them.
Thank you, Senator Torres. Senator Therese Terlahi, you are recognized.
Thank you. I guess I'm just a little, if I could request some clarification perhaps by the sponsor of the amendment, because so the amendment is to add this new subsection B, which would say the Attorney General gets 180 days to issue opinions to members of the legislature, individual members. 180 days, 6 months. If not, there's a fine. But earlier in this section, what used to be B, if you look on the page prior, subsection, it's newly renumbered subsection 2, there's a requirement that the AG provide these legal memorandums and opinions to the requesting senator no later than 30 calendar days. or be subject to the fine. I think they conflict with each other. I support the 30 calendar days, and of course, there will be some that might take longer, but I think that they should be able to explain that, and that 6 months might just be giving too much time, because I don't see that this request is abused. I think it's very important. We're talking about things that our legislative council is not supposed to opine on, and that the Attorney General's opinion is crucial. It's the crux of the matter, because we normally want to agree with our Attorney General. So we want to know what is their position on something, how do they interpret a law, or do we need to fix it, right? To be corrected, or is it being interpreted correctly? Almost always when we write to them, we feel like it's urgent, because we want to know if something's being applied correctly. For example, when we had the big questions about the CARES Act money expenditures, were they subject to the procurement law or not? But so I just don't want to give 6 months. That's like, for us here, a third of our term, and very difficult to move forward if we can't get answers. So I would like to, be reasonable. Ask them for 30 days to give it to us, as the bill says, and then, if they have an explanation why it can't be done, I'm sure they can communicate that. But I guess, part of the issue that we're seeing right now is that we just haven't been given any explanations as to why we're not receiving one before the other, and then one had requested earlier and the other one came out earlier, that type of thing. And I think that's easily solved with just more communication. So I would encourage more communication, and that, we can see that they're treating all members fairly, that they're trying their best to get these things out, and I'm very understanding as to if it would take longer, if an explanation is provided. So I think there's a conflict in this amendment, and that I would suggest we stick to the 30 days. Thank you.
Thank you. Anyone else wishing to speak on the amendment? Senator Lee, followed by Senator Rijel.
Susan Smasi, Madam Speaker. Madam Speaker, I rise in support of this amendment. I believe that this amendment is a reasonable compromise that really ensures that the members of this body will receive all of the requested legal opinions from the Office of the Attorney General, while not unduly adding to the demands and the mandates of this already understaffed and underfunded agency, which, just for the record, colleagues, they field an average of 220 requests for opinions like this each fiscal year. So especially given that the Attorney General's office is dealing with more than a $5 million cut to their budget, this is on top of all the other challenges that the things that they're having to deal with because of the pandemic and many other issues that they're faced with. So, Madam Speaker, I also remain concerned that while I support the intent of this bill, I believe that there are many scenarios where the Attorney General cannot immediately opine due to either ongoing criminal or civil cases that might restrict their ability to ethically respond to some of these requested opinions. There could be, knock on wood, God forbid, any illness of the Attorney General that would not allow either him or her to respond within 7 days, or members of their staff falling ill that kind of would take the lead on something like this. And so I think that there's a number of different scenarios that certainly raise my level of concern and raise caution, I think, to all the members of this body. We don't want these opinions to be rushed either. We want them to be thoroughly vetted and considered. And I think that the Attorney General's office has been good enough to share some of those responses with us in the hearing of this bill and in subsequent communications. So I certainly rise in support of this amendment, Madam Speaker, and I urge my colleagues to, do the responsible thing and also support this. Thank you.
Thank you very much, Senator Lee. Senator Richel, you are recognized.
Thank you, Madam Chair. I support the amendment proffered by Speaker Tina Muñoz-Barnes and Senator Mary Torres. I'm concerned with placing deadlines like this actually at all. As the Attorney General mentioned in their office testimony, many jurisdictions don't have a deadline. Most jurisdictions just say as expeditiously as possible. Here we are putting a deadline on an office that's already stretched pretty thin. They have a lot of other things they have to deal with, not just our requests for opinions on every single little matter. They have to prosecute cases, they have to defend the government of Guam in any court cases, and they're actually the legal counsel considered legal for the executive branch, not necessarily the legislative branch. And we have our own legal counsel. We have a legislative legal counsel already. Part of the testimony that the Attorney General's office submitted said that they've had requests to interpret our standing rules. That's something I didn't even know. I've never asked them to interpret our own standing rules. Those are our standing rules. If anyone should interpret them, it should be the body that created those standing rules. So when I found out that they've actually entertained requests to opine on our own standing rules, I think that's taking it too far. I think that shows the level of requests that we're submitting to the Attorney General's office is probably well beyond the scope of what we should be submitting to the Attorney General's office. They shouldn't be here to answer every single argument we have. It's up to us to argue with one another over the merits of certain bills, over the merits of provisions in bills, over our own standing rules. We should not be looking to the Attorney General's office to be a referee. That's not their job. Their job is to provide legal opinions on certain matters where we may be concerned that it could end up in court. That I understand. But taking it to the level of asking for opinions on our own standing rules and every little thing, I don't know what else has been asked, but I'm assuming that a lot of other things have been asked. That's why we have our own legal counsel, our own legal bureau. That's why we have our staff members who are supposed to research bills, research other jurisdictions and how laws are handled and interpreted in other jurisdictions. We shouldn't be relying on them to do our work for us. And based on their testimony, that's beginning to sound like what's been happening. So with that, I rise in full support of the amendment proffered by Speaker Tina Muñoz-Barnes and co-sponsored by Senator Mary Torres. Thank you.
Thank you very much, Senator Richel. Is there anyone wishing to speak on the amendment?
Madam Chair, can we just, the amendment that I'm seeing now on upload is totally different than the one that we received earlier. So sorry, I was speaking on a wrong amendment.
We'll take a moment's recess.
Thank you.
35 the legislature in Guam is back from recess. The clerks have fixed the amendment in the drive, and so it has been corrected. There was a request from Senator Terlahi to continue speaking on the amendment. You may continue.
Okay, so yeah, the new version I'm looking at now is actually significant changes to the bill. It pretty much substitutes the entire bill. It takes away the provision that the speaker and the minority leader would be able to request like an expedited opinion within 7 working days or 10 working days if necessary upon explanation by the Attorney General. And it takes away the 30 days deadline to respond to all other senators. And for all legislative requests, it gives a 180-day deadline. And I would rather not do this bill than give them a 180-day deadline, because to say that it's okay to wait 6 months to issue a legal opinion, we're only supposed to be asking for legal opinions. So I don't, one of the previous speakers spoke about asking opinions on the standing rules. Of course, that's just not correct, because the statute right now requires that the AG is going to give us opinions on matters relating to enacted laws or the status of case law on a given subject. That's it, enacted laws. That's the reason why we're going to the AG, because the AG's opinion on an enacted law tells us whether he's going to enforce it or he's not, whether something's legal or it's not. And those are almost always urgent. So I thought it was a pretty big compromise, the amended version that came out of committee, that allows only some of our requests to be urgent and the rest to be, regular, 30 days, or else an explanation to explain why longer than 30 days. And I have absolute faith that explanations will suffice if they are given. And the only issue we have had, and why this bill even had to come forth in the first place, is we had no explanations. No explanations why some opinions were not being issued, no explanation why some were being deemed more urgent than others. That's all. Not that we found, we cannot be finding that these are not important. They are so critical. They've been in statute for years because they are critical to how not just us, but the public is going to function. They need to know if some things are legal or they're not. And they need to know it right away, not when it's too late to do anything about it. When we were considering, whether we can give, what do they call it, incentive pay, or I can't remember what was the type of pay we were considering, we had to know whether they were getting paid double pay. We had to know those things. They were fundamental to how we were going to move forward. And only the AG's opinion matters, because only the AG can take the government to court or represent the government. And we want to know what side he's going to be on when these matters go to court. Whether he's going to enforce the law or he's going to say, unenforceable. So I very much object to saying that 180 days, 6 months is okay for anyone in the government to operate that slowly. No, I disagree. And especially when it comes to requesting opinions, and they can scold us if they want to, that we're asking them silly questions. I mean, fine, they should do that if we are asking them silly questions about our standing rules or I don't know what. But they should answer, and these are, again, interpretations of law that only the AG's opinion matters. We need to know sometimes whether agencies are operating in compliance with law, and I think that's almost always the pressing questions on us. These agencies are doing it this way. Is that legal or is that not? Is that how you interpret that law or not? Because we definitely might say, we didn't intend that outcome, let's fix it right away. We're losing money or whatever's happening. So I just think for not just us, but for, the rest of the government, that we need prompt answers from the Attorney General. And I think 180 days is not going to be adequate for those purposes. Thank you. So I object to this amendment.
Thank you, Senator Therese. Senator Marsh Titano, you are recognized.
Sainama Asi, Madam Speaker. I agree with the retiring speaker in that the 180 days, I know it does exist, I think it's in Texas, but it does seem like an extraordinarily long period of time. And so from early on, I had been thinking about a compromise, and they had mentioned in the testimony that, I believe it's Montana, but one of the states anyways, does list 90 days. So ideally, they don't take that long, but to ensure that there is a deadline and that it shouldn't be taking longer than that. So I propose to amend the 180 days to 90 days.
Thank you, Senator Marsh Titano. On the amendment to the amendment, is there anyone wishing to speak? Senator Titano, you are recognized.
Sijus Masi, Madam Speaker. I've always respected the previous speaker, always trying to find a compromise and rethinking things out. And I wish he was there when we had the meeting with the Attorney General, myself, and Senator San Augustine when we discussed a compromise. And it was in that discussion that we had that the compromise was 30 days, and to allow an extension with a written reason why they need the extension. So that was the compromise, the 30 days. So, Madam Speaker, I respectfully have to object to the amendment.
Thank you, Senator Titano. There's been an objection to the amendment. Is there anyone else wishing to discuss? Senator Titano, would you like to close?
Well, as I was mentioning, trying to think about what is going to be a deadline, what is going to serve needs on both sides. We do realize, at least especially at this point, the office is underfunded, understaffed, and it does have many responsibilities. So with this, I do think that 90 days is definitely more reasonable than 180 days. So with that, I'd just like to call for the vote.
Thank you very much, Senator Marsh Titano. On the amendment to the amendment, there has been an objection, so all those in favor, please raise your hand. In favor for the amendment to change 180 days to 90 days. Amendment passes. We are still on the Munya Barnes amendment as amended. Is there anyone else wishing to speak on the amendment as amended? Speaker Barnes? Oh, I'm sorry, Senator Rajel.
Thank you, Madam Chair. I'd like to thank the author of the amendment to the amendment. I think now it's a very good compromise at 90 days. Initially, as I stated earlier, I think there shouldn't be any actual deadline at all. And one of the previous speakers mentioned something about the real concern that brought this bill about has something to do with priorities of whose opinions are put out first before others. Well, that's not what this bill does at all, and that's not what any of these amendments address either. These amendments are addressing a deadline of time. Nothing in it has to do with who's being prioritized over who. So if that's the case, that's a completely different bill. Nevertheless, this is the bill we're discussing now, And while I think there shouldn't be, if the real concern is that people are being bypassed and other people are getting their opinions out first, then there should be another bill addressing that. We shouldn't be addressing a deadline at all. But with that, I thank the sponsor of the amendment to the amendment in seeking a compromise with 90 days, and I think that makes it a much more fair process for everyone involved. Thank you.
Thank you, Senator Rochelle. Anyone else on the bill? On the amendment, as amendment. Speaker Munya-Barnes, you are recognized to close. Okay, there has been an objection to the amendment as amended. And Speaker Munya-Barnes, would you like to close on your amendment?
Thank you, Madam Speaker. Madam Speaker, in the interest of time and sharing the compromise that was proffered by the previous speaker, I'd ask that in fairness, I'd go ahead and ask for the vote. I understand, and I hope that my colleagues can at least consider this effort moving forward to give the Attorney General's office that timeline.
Thank you very much, Madam Speaker. On the amended, as amended, there has been an objection. Please raise your hand. I'm calling for the vote on the amendment as amended. Amendment fails. Speaker, would you like to continue on the bill?
Yes,
Thank
I know
you.
I still have a little time, Madam Speaker, thank you. And based on what has just happened, some of my concerns that have come up in reference to this bill, Madam Speaker, is, for me, is what if the Attorney General falls ill, or one of his staff falls ill within the amended bill's time standards? Is there any exception? That's one. Two, Madam Speaker, what if there's a typhoon or a natural disaster? Is that an exception? Three, Madam Speaker, what if the opinion being requested is related to an item the Attorney General believes will have a negative impact on an ongoing court case or could jeopardize the future of planned legal strategy for the government? Should they be forced to respond, Madam Speaker? So with that being said, Madam Speaker, I now have concerns with this bill as proffered, and I will continue to, well, maybe I should ask, turn those questions and ask if the author of the bill can answer as it relates to what ifs and are there exemptions?
Thank you, Madam Speaker. Will the author yield to the question?
Yes, Madam Speaker. Well, if the Attorney General falls sick, that's why we have Assistant Attorney Generals that are on board. Several of them, if I'm not mistaken. If there's a typhoon that comes into play, I'm pretty sure we all can understand, and the explanation will be given to us from the Attorney General as it stipulates in this law to give us a reasoning. And it's justified. I'm sorry, there was a typhoon, if he falls sick. There was a third one that was mentioned. I'm not sure what that is, Madam Speaker, the third for instance.
What if you'd like me to repeat it, Madam Speaker, I can go ahead and repeat it. The third question is, what if the opinion being requested is related to an item that the Attorney General believes will have a negative impact on an ongoing court case or could jeopardize the future planned legal strategy for the government? Should they be forced to respond?
Thank you, Madam Speaker.
Thank you for the clarification on the third question, but I'm pretty sure when there's something that is legally bounded by the Attorney General's office to not provide any type of explanation, it's legally bounded. We can't supersede that. It's as simple as that.
Thank you. Madam Speaker?
Thank you, Madam Speaker, for giving me the time to ask these questions. And with that being said, I again will listen to the other recommendations from my colleague, but share with you that I have grave reservations about this bill moving forward, as I think that the timeline to provide for the AGs is not reasonable. Sainamasi.
Thank you. Anyone else wishing to speak on the bill? Senator Marsh Taitano, you are recognized.
Sainama'asi Maskehelu. I do have an amendment that is loaded up, and let me open it myself. This is for line 12, page 2, to amend section 1 of the bill to read, "The Attorney General shall be granted an extension of 7 working days to issue the legal memorandum or opinion requested by Legislature in Guam pursuant to this subsection, and the administrative fine shall be waived only after a written notice is provided to the Speaker and Minority Leader briefly explaining the reasons for a delayed response." So it crosses out 3 and it makes it 7 working days. And this in totality gives the AG's office 14 working days, or a little over 2 weeks, to come up with an opinion. And in this case, as has been mentioned by some of the earlier speakers and the author herself, that there are particular cases where the entire body is coming together and there is perhaps something pressing. So it does seem that there is good reason to have some expedited opinions, especially if the entire body is seeking this and has agreed upon it. But to give a little bit more time, again, as is needed, to provide a little more flexibility and make sure that we are getting a more sound, perhaps, and a more researched opinion, which I think is what we would all want.
Thank you, Senator Marsh Taitano. Is there anyone wishing to speak on the amendment? Senator Taitigui, you are recognized.
Madam Speaker. I'd like to thank the author of this amendment. Always, like I said, she's always there trying to compromise, and I greatly appreciate it. I have no objection to this amendment, Madam Speaker, but we also have to remember, what about FOIA's, Freedom of Information Act? They're given a timeline to be responded to. And that's all we're doing here with the Attorney General's office, is asking for a timeline as well for this legislative body to provide the information they need to put sound legislation through this body, and for us to even vote on something that we feel comfortable knowing that the Attorney General has opined to that particular circumstances. So I have no objection to this amendment.
Thank you, Senator Taitigui. Anyone else on the amendment? Senator Marsh Taitano, you may close.
Sainama'asi, I will not need to close on this. Masi.
Thank you very much. There being no objections, the amendment passes. Anyone else on, oh, yes, Senator Marsh-Titino, you may continue.
Yes, I did have one other amendment, and it's to take the 30 days and to amend that to 90, as we had discussed previously. Again, there is a lengthy list of responsibilities that the office has. Ideally, we are looking towards an opinion that would come out in a week or a couple of weeks or 30 days, but some opinions are going to be more complex. Sometimes there are multiple issues going on at the same time. And as I mentioned, they had given us a quite lengthy list of their sets of responsibilities. And so it's to provide them the opportunity to balance these things out. They talked about advising agencies on personnel matters, particularly adverse actions and agency investigations, reviewing and approving all intergovernmental and intragovernmental agreements, reviewing and approving for form and legality all government contracts, providing legal service in all phases of all procurements above $500,000, representing agencies in appeals from procurement protests, developing procurement templates and forms for agency use, advising, assisting with reviewing and approving agency administrative rules and regulations, advising and assisting boards and commissions, representing agencies in administrative adjudication hearings and processes, assisting agencies in responding to time-sensitive FOIA requests, and providing training on procurement and FOIA and other types of actions. So I agree with others that have spoken. I too want these opinions in a week, in 2 weeks, and in 30 days. But I do think that providing a little bit of flexibility so that as is needed, there may be times when more time is needed again for it to be sound and quality opinions that we're receiving.
Thank you very much, Senator Marsh-Titino. To clarify, your amendment is to change 30 calendar days to 90 calendar days on page 2, line 21.
Yes.
Thank you very much. Is there anyone wishing to speak on the amendment? Senator Tittingly, you are recognized.
Sidus Masi, Madam Speaker. And Madam Speaker, there was the same attempt, to change from 30 days to 90 days, and it failed. And, Madam
Point of information, that part passed. That part passed. The entire amendment did fail, though.
Yes.
You have to address.
Yes.
On a point of information, Madam Speaker,
Yes, Madam
can you
Speaker,
please
you're
ask
recognized.
my colleagues to speak to the podium just as a point of justification on the issue?
Thank you. As a reminder, please address the podium. Senator Tittingly, you are still recognized.
Thank you, Madam Speaker. Madam Speaker, I respectfully object to this amendment. Thank you.
Thank you, Senator Tittingly. Is there anyone else wishing to speak on the amendment to change 30 calendar days to 90 calendar days? Page 2, line 21. Senator Ridgell, you're recognized.
Thank you, Madam Chair. I support this amendment. We passed this amendment already, but the underlying amendment didn't pass. I think part of the reason for that may be because the underlying amendment also struck out another section in the bill, another part of the bill where it says that the legislature would be able to submit a request via the speaker or minority leader, and that the AG would provide the legal memorandum or opinion within 7 working days. So that part was struck out of Speaker Barnes's underlying amendment that was amended to 90 days. So that's the difference between Senator Marsh-Titino's current amendment. So with her current amendment, there's still the ability for the speaker and minority leader to request for an opinion and then 7 working days for that to be submitted. What this changes is that now other members if they're seeking legal memorandums or opinions, then now the AG would have 90 days. So there would still be a way where the AG would only have 7 days to provide the legal opinion, but now this makes that only available if it's a written request signed by the speaker or minority leader. Excuse me, actually it says signed by the speaker and minority leader. So I support this amendment. It's certainly different than the last one, because again, the underlying amendment isn't there. All this does is changes page 2, line 21, where now it says that the Attorney General will have to provide its legal memorandum and opinion to the requesting member, any member, no later than 90 calendar days. Again, I think this is a good compromise, so I'm in support of this amendment. Thank you.
Thank you, Senator Richel. Anyone else
Madam
on
Speaker?
the amendment?
Is this on, Madam Speaker, if I may, I'm just trying to point of inquiry, is this amendment online? Because I'm trying to find the amendment, and I don't see it online.
Thank you. Please refresh your page. We'll take a moment's recess. Yes, yep. Oh, we are back from recess. You can find the amendment listed as AB377KMT L2 1P2 if you refresh your drive. Thank you very much. Anyone else wishing to speak on the amendment? Senator Terlahi, you are recognized.
Thank you. I'd like to amend that amendment so that we keep 30 days, but we say that a 30-day extension can be requested multiple times, up to 90 days. So, with upon explanation, so that they just can continue to keep whoever's requesting that opinion updated every 30 days. 30 days, I think, is sufficient to at least have a sufficient reason why it's not being done. And that way, it gives within 30 days, if there's no answer, that can be reported to the speaker and the minority leader, and perhaps they can ask that it be treated urgently if it's not. So I think they're starting to send that in. I'm not sure if you got it yet, but let me see.
Thank you very much, Senator Terlahi. Can you repeat what your amendment is?
Yes, so it would be,
Madam Speaker, can we take a short recess, please?
We are in recess.
I'm just going to,
We are back from recess. Senator Terlahi, you are recognized.
thank you, Madam Speaker. I'm just going to withdraw that amendment. Thank you. That amendment to the amendment is withdrawn.
Thank you very much, Senator Terlahi. On the motion to withdraw, any objections? Motion passes. Anyone else wishing to speak? Oh, Senator Terlahi, you may continue.
I was objecting to that, sorry. Yeah.
You're objecting to your withdrawal of your
Oh, no, I'm sorry.
amendment.
See, I'm getting confused. No, okay, I thought you were, that's why I was alarmed. I thought you were voting on the original amendment. No, of course I don't.
On the withdrawal of your amendment to the amendment. Thank you. Anyone else wishing to speak on the amendment? No one wishes to speak. Senator Marsh-Titino, would you like to close?
Ahi, I'm fine with it moving forward, Sejus Masi.
On the Marsh-Titino amendment to line 21, page 2, to strike 30 calendar days and replace it with 90 calendar days, there are no objections. Oh, there was an objection. I will call for the vote. All those in favor of the Marsh-Titino amendment, please signify by raising your hand. Motion fails. Anyone else on the main motion? The main motion? Senator Therese Terlahi, you are recognized.
Thanks. I would just want to briefly point out again that, we should be mindful what we are asking of the Attorney General. They are, again, only supposed to be issuing opinions on laws that exist or case law as to certain topics. And the current statute says that all legal memorandum or opinions, except those prepared with regard to actual or pending litigation, or which give opinions on matters which in themselves are not public, shall be public. So it gives them that out for those matters that are pending litigation or, confidential for other reasons, protected by privacy laws. And that's, I guess, all I want to say on the bill. Thank you.
Thank you, Senator Terlahi. Anyone else on the main motion? Senator Bisco-Lee, you are recognized.
Sejus Masi, Madam Speaker, and I just have two questions for the author of this bill, if she would yield.
Please state your question.
Sejus Masi, Madam Speaker. So I guess my question is, what would happen, or what would need to happen if the Attorney General needs the services of a subject matter expert, or is for some reason unable to respond to us because the AG lacks expertise in a certain field or a certain issue of concern, especially within this very tight timeline that's been being mandated by this measure? Is there an exception to this if additional information or additional subject matter expertise needs to be sought in order to give a thorough and effective opinion?
Senator Taitukwi, do you yield to the question?
Yes, ma'am, Madam Speaker.
You're recognized.
Thank you, Madam Speaker. Like circumstances where the Attorney General actually can hire outside of the Attorney General's office, for instance, if they need litigation attorneys, like let's start with the Chamorro Land Trust. They hired another attorney outside of the AG's office to assist with the Chamorro Land Trust dealings. I believe there was litigation with the Highsmith case where I believe Attorney Lemon was brought in as the private sector brought in. So this doesn't stop the Attorney General's office from also utilizing any private sectors and hiring individuals to assist the Attorney General's office. So if there's anything with regards to expertise or I mean, majority of our requests here have to do with law, and the current laws and the Organic Act of Guam. I don't think if we're looking at any other situations, then it doesn't limit them from being able to go outside the Attorney General's office and seek help, like they've done in the past.
Thank you, Senator Taitugui. Senator Biscoli?
Sujasmasi, Madam Chair, and I think that the response by the author of this bill also kind of highlights an issue that could come to fruition if this bill were to become law. I mentioned previously that the Attorney General's office has been responsible for dealing with over 220 requests for opinions, not just from our body, but from many agencies across our government. And they're also saddled with a $5 million cut to their budget. And so it's easy to say, oh, you can just hire out, but if you're strapped for time and you're strapped for cash, then those options become rather limited. So, Madam Speaker, I just, I rise with a lot of concern for this measure. I wanted to have the opportunity also to ask the author of this amendment if we're aware if any oversight hearings have been called of the Attorney General's office for delayed response. Have we had an oversight hearing, as is our responsibility and our duty in this branch to provide the proper oversight? Has there been an oversight hearing for this particular concern?
Thank you, Senator Biscoli. Senator Taitui, do you yield to the question?
I'm not really sure about the question. Has there been an oversight? I'm not quite sure what she's trying to get at. Maybe if she can clarify a little bit more so I can understand what the question is, if there's ever been an oversight. I can tell you, Madam Speaker, that we have met with the Attorney General's office, myself as well as the committee chair, and met through a Zoom meeting and discussed this legislation and made the changes that was requested in the first email that was sent back to us after this meeting. So I'm not quite sure, but if she can elaborate on what oversight.
Will you clarify your question?
Absolutely, Madam Chair. I'm happy to elaborate. As all of the members of our body know, we have three main duties as senators. One is to introduce and move to go through our body and pass legislation. One is to make accommodations for the budget of the government of Guam. And our third duty as senators of Legislature in Guahan is to provide proper oversight. And so I guess the point I'm making, Madam Chair, is that I certainly believe that the Attorney General and their office should provide these important legal opinions based on merit and not on politics. I also believe that this body has, again, this oversight authority it can exercise to root out any malpractice on the part of any public official during the process of issuing these opinions. And Madam Speaker, I guess what I'm getting at here is that we can accomplish the goals of this measure without saddling an agency that just received a $5 million budget cut on top of its perennial funding shortages with undue burden. 220 legal opinions from this body and from agencies under the government of Guam. There was a mention by a previous speaker of, different attorney general's offices in different jurisdictions and how many people in their population are represented by those attorney generals. But they also have massive budgets that they can deal with. They have the resources to be able to put out these opinions rapidly. They have access to many legal minds in a lot of these jurisdictions. Where out here in Guam, it's been challenging for the Attorney General and other members of the judiciary and other agencies in our government and even in the private sector to get attorneys to come and to work here. So it's just been a huge challenge to look at this bill and to be able to take it seriously, because we're attempting to saddle this agency that's already had a budget cut, that is already working so hard with less resources. And so, Madam Speaker, as this bill stands, there are really no exceptions, no extensions granted for, acts of God. For this pandemic, for the need to consult subject matter experts, for extraordinary caseloads, and I can go on and on and on. And I wish I could throw my support behind this bill. But with all of the amendments that were proffered, that were struck down, Madam Speaker, I don't think that it strikes the correct balance. And I don't think that we have done everything in our power to find out, to get to the root of the problem at the Attorney General's office and, have them come in and work with them. This measure has not done that, Madam Speaker. Each of us as members of this body haven't had the opportunity to have an oversight hearing so we could all have our questions answered. It's great that the author of this measure and maybe one other senator was able to sit down with the Attorney General, but the rest of us didn't have that opportunity. And so that's why I bring out oversight, because that is our job. And we should be well aware of what we're here to do. That's all I got.
Thank you very much, Senator
Point of
Lee.
inquiry, I think there was something about an oversight still did not get answered.
Point of information.
I'll recognize you for your point of information, Senator Terlahi.
Thank you. Yes, at the public hearing, the Attorney General himself was not present, but he sent a representative, the one that has been assigned to take care of legislative matters. So I just want to say that was, otherwise that would have been an opportunity to have any discussion that we wanted with the Attorney General. But what I really wanted to point out is that in regards to oversight, right now, the Attorney General does not have to report, and neither does any of you, my colleagues, have to report to me
Point of order,
what you're
Madam Speaker.
asking the Attorney General to
Point of order, Madam
opine
Speaker. I
Did your
believe
point of order, Senator Lee?
I believe the senator has already made remarks on this measure. Is this an additional?
Yes, this is
Senator
a point
Terlahi is offering a point of information.
Correct. As to, the requests for opinions to the Attorney General are not public. I don't know, unless you guys want to change the rules, and we're going to all know what requests each of you is making to the Attorney General's office. That's never, ever been raised as a part of this or any matter. They don't
you, Senator
disclose, and
Terlahi.
neither do senators disclose what requests are being made until after they're answered.
Thank you very much. Anyone else wishing to speak on the main measure? Senator Rajal, you are recognized.
Thank you. I raise an objection to the main measure. We tried to work on some compromises. We tried for 180 days. We tried for 90 days. While the author of the bill has stated that the 30 days present in the bill is a compromise, based on a meeting she had with the Attorney General, the testimony we have from the Attorney General, which was submitted this evening via email at 6:08 p.m., says that the Attorney General's office is in opposition to the amended bill. Specifically, they point out that they believe it's not practical. What they do offer as a compromise in their written testimony submitted to the legislature this evening via email, they say, quote, if this body should decide to impose a deadline on the issuance of opinions despite this impracticality, we ask that Guam be given at least the same consideration as the very few AG's offices across the country where such a requirement is imposed. As stated in our public hearing testimony, 3 jurisdictions that set deadlines for AG opinions do so as follows: 180 days, 90 days, and, quote, as expeditiously as possible. So I take that to mean that the compromise that the Attorney General's office is seeking in writing is that if we are going to put any sort of restrictions on them, let's put it at 180 days or 90 days or as expeditiously as possible, which is basically no days, no restriction. So with that, I have to object to the bill and register my objection to this bill because I don't think it seeks a compromise as per the written testimony submitted by Stephanie Mendiola, General Counsel for the Attorney General's office that she sent this evening. Again, the compromise they're seeking, according to this email, is 180 days or 90 days, which we tried. So now I think instead of seeking a compromise, we're just seeking to force them to give us opinions in a timeline that they say is impractical. And I don't think that's fair. Especially considering that we in this body should be very well aware of the practicality of submitting reports, of reporting bills out of committee. There's numerous bills that haven't even made it out of committee, that have been sitting in committee for over a year, year and a half at some times. And now we're expecting another agency to turn around an opinion to us in 7 days. But we can't even do that ourselves. So that's why I think we should all realize that this is impractical. And with that, I register formally my objection to the measure in its entirety. Thank you.
Thank you, Senator Rangel. Anyone else wishing to speak on the main motion? The main motion. Senator Titlegy, would you like to close?
Sijus Masi, Madam Speaker. Madam Speaker, some of the comments that were made earlier, it's on, to me, my personal opinion, my opinion as a senator, some of them, had good, comments being made, but some were just, it's like, okay, if we're going to give up putting a timeline on anything, then we might as well just, not put a 10-day FOIA that we have already in law, or all the other laws that we have in place that put a timeline. Other agencies also have timelines to deal with, and as legislators, it's important that if we're going to move forward on any kind of legislation, we do it cautiously, we do it with the assistance of our own legal bureau, but the majority of time we have to seek the Attorney General's opinion because sometimes that's the only thing that matters or anybody accepts. In closing, Madam Speaker, I'd like to share that since the early part of the 35th Guam Legislature, I sought guidance from the Attorney General's office on a number of issues. These matters of concerns included whether legislatively imposed restrictions on hiring of deputy directors and other unclassified employees were permissible by law, clarification on the number of votes required to pass legislation, term limits for senators, questionable use of public funds, legislative procedures involving debate on non-reported bills, recommendations for amendments to the child support statute, and use of unappropriated general fund revenue outside of an appropriation authorized by the Guam Legislature. These are important questions to ask. Madam Speaker, it's disappointing for me to recognize that this legislative term will end in about 2.5 weeks from now without my office hearing back from the Attorney General on a couple of these issues. And these questions were asked would help craft legislation that would help the people of Guam. But we can't move forward because we don't have the Attorney General's opinion, or that we want to do it cautiously and ensure that what we're passing, what this legislature here, this body does, is making a sound decision on how they vote. Whether it is holding an agency director accountable for delays that impact the timely and necessary review of land use applications, proposals by the way that could potentially create new jobs by expanding economic activity, or requiring the Attorney General's office to add critical questions within a reasonable period of time. Senators must continue to ensure that public officials are held accountable for their actions or lack thereof. With this, Madam Speaker, I humbly ask my colleagues for their support of Bill 377 as amended, which would help us in the 36th Guam Legislature. Thank you, Madam Speaker.
Thank you, Senator Titlegley. On the motion to move to the voting file.
Thank you, Madam Speaker. With that, I move to place Bill 377-35 COR to the third reading file.
Are there any objections? There has been an objection.
Madam Speaker, I'm sorry.
There has been an objection
by
to
who?
your motion.
Senator Rigel, okay.
Thank you very much. There has been an objection to the motion to move the bill to the voting file, Bill 377-35 to the voting file. All those in favor of the Titlegley motion to move
Madam
to the
Speaker,
voting
if I
file.
may, 1 minute, please, Madam Speaker, because the question that's being asked may have 1 minute, please.
To clarify, this is a motion to move Bill 377-35 to the third reading voting file. There has been an objection. We'll take a moment's recess. We are back from recess. On the motion to move Bill number 377-35 to the third reading voting file, there has been an objection registered. All those in favor of the motion, please signify by raising your hand.
Can you repeat that, please? Sorry.
On the motion to move Bill number 377-35 to the third reading voting file, please signify by raising your hand. Those in favor. Motion fails. We are now on Bill 402-35 COR. Speaker Tina Munya-Barnes, you are recognized.
Madam Speaker, and I'll try my very best to be brief. I move to place Bill 402-35 COR as amended by the Committee on Heritage and the Arts, Parks, Guam Products, Hagåtña Revitalization, Self-Determination, and Regional Affairs, which is a bill authorized by myself, which is an act to authorize the extension of the term of the use agreements of properties recognized by the Guam Football Soccer Association, GFA National Training Center in Dedido, and the Southern Sports Complex in Agate, between the Department of Parks and Recreations and the Guam Football Soccer Association for a term of up to 20 years. To the third reading, and if I can discuss it.
Thank you very much, Madam Speaker. You may proceed.
And if I may, before I start discussion, I'd like to add as a co-sponsor, Senator Kelly Marsh Taitsino.
On that
My vice-
motion, no objections.
Speaker, for giving me the opportunity to speak on this bill. I sponsored Bill 402-35 COR at the request of the Guam Football Association, GFA, to assist them in their efforts to secure additional grants with the Federation International Day Football Association, FIFA, and further develop our infrastructure as well as our youth. This partnership, Madam Speaker, between the government of Guam and the GFA has been a win-win solution and a great investment in our community. GFA has not only developed and improved government property into something the community is proud of with little government funding, but they have developed our youth, getting them physically active and family as they spend more time with one another. The Guam Football Association, GFA, has a proven record of success in our community, and I hope we can continue to create more partnerships like with our private sector in the future. Very briefly on the bill, section by section, this bill authorizes the extension of the term of the lease between Department of Parks and Recs, DPR, and GFA for a term of up to 20 years. The GFA has been a member of FIFA since 1996 and has been successful in obtaining grants from FIFA to build sports facilities on Guam, and in order to secure additional grants from FIFA, GFA has requested an extension of the term of the lease with the Department of Parks and Recreation for the term of up to 20 years. Section 2, term of the lease was removed and replaced with an extension of use agreement for the GFA National Training Center soccer facility. It specifies the lot to be leased in Dedido as provided in Public Law 24-33. And although the amended section approves the extension by the legislature, it still, Madam Speaker, requires the following for it to go into effect. Signature, the governor must sign, the lieutenant governor must attest to the signing, and must be approved by the Attorney General. It specifies the area of the lot, number 10142 New 4, and the description is also noted. C, the term of the lease, license agreement, covenants, and conditions contained under the original agreement is extended. D, government of Guam is not liable for any indemnity arising out of the licensed premises. E, it requires GFA to comply with all laws applicable in the use of the Memorandum of Understanding premise. And F, it protects the government of Guam from liability incurred by GFA. Any debt incurred by GFA shall not be the debt of the government of Guam. All government of Guam shares of revenues collected in the use of the premises shall be deposited into the Public Recreational Service Fund. And the amended bill also adds a new Section 3, and it's the extension of the use agreement for the Southern Sports Complex. A, it approves the MOU extension between the Department of Parks and Recs and GFA and specifies the lot to be leased. And although the amended section approves the extension by the legislature, it requires the following to go into effect. That specifies the area and the lot number, and it lists the lot number down, and then C, the terms and conditions under the MOU are the same. However, the assignment of the MOU shall require the concurrence of y Legislature and Guam, and then D, it protects the government of Guam from liability incurred by GFA, and it requires GFA to comply with all the laws in the use of the MOU premise, and then any debt incurred by GFA not be a debt of the government of Guam. And then Section 4 is the severability clause. And then, of course, there was a fiscal note, and based on the comments received by the acting director of DPR, his concerns on the bill revolve around the need to extend the lease for another 20 years when the existing memorandum agreement for the MOA between DPR and GFA for the Northern Sports Complex expires on December 31st, 2029, and the MOA for the Southern Sports Complex expires on 2039. And although the extensions of the lease is administrative in nature, the continuance of this partnership would further allow the GFA to assert additional grants from the Federation's International Day Football Association, which is FIFA, Madam Speaker, to build more sports facilities on Guam and programs to develop Guam's youth. And however, absent an additional information regarding the extent of the grants obtained from FIFA, the Bureau is unable to determine an appropriate financial impact at this time. But I will note, Madam Speaker, that when you're looking at $1.3 to $3 million in grant money from FIFA, and something that Guam barely can get its hands on, I think that this is truly a win-win, not just for our youth in the sport of soccer, which is called internationally football, but it's a win-win for the development, it's a win-win for the education, the discipline of the sport, it's a win-win for the youth, and it's a win-win as we continue to promote Guam to the rest of the world. Again, this is the reason why the extension is needed. When we were at the public hearing, Madam Speaker, it was noted that in order for them to release that large sum of money, there needs to be a commitment from the governor and from the government, and it's important to know that as we have seen the successes in the past since the original introduction by the late Speaker Ben Pangilinan, I think this is truly a win for everybody. Back then, Madam Speaker, you would see the sport of baseball as one who had fields in every village of the island. Today, we see not hundreds, but thousands of kids and family members all coming together in playing the sport of soccer, but it becomes a family event, it becomes an educational training event, literally also promotes the island, like I said earlier, to the rest of the world, and we've seen the successes of that too, Madam Speaker. So I literally ask my colleagues to support this effort at their request, and I'm hoping that with the extension and with the approval that we will realize anywhere between $1.3 and $3 million. Thank you, Madam Speaker.
Thank you very much, Speaker Tina Munoz-Barnes. Is there anyone wishing to speak on the main motion, Bill 402-35? On the main motion. Senator Mary Torres, you are recognized.
Yes, if the good author of this bill will yield, I would like to know, with regard to the MOU and the license agreements, will it be a carryover of the original agreements, or will there be the opportunity for the legislature to reconsider or revisit the MOU agreement or the license agreement for the lease of these properties. So is it a restart with the next 20 years, or is it just the same terms and conditions?
Thank you. It's an extension of the terms that's already existing today. As you know, based on both of them, it doesn't reach the 20-year max, so it's to increase to the 20-year timeline. And it was through the efforts at the public hearing was noted was that FIFA wanted to see the commitment from the government and making sure that if they're going to put all that money into the island of Guam to build the facility down in Agate and then further advance what we have existing today, that they wanted a commitment from the government, and this was the way of doing it. So it is to extend it up to at least half the 20 years. And it doesn't have it right now.
Thank you, Speaker. Senator Torres.
Okay, so then what was signed then in, I guess Governor Gutierrez was the governor at the time that all of this was signed. So that more or less is the same terms and conditions, it's just an extension. I just wanted to be clear about that. So I guess it's been answered. Thank you very much.
Thank you very much, Senator Torres. Anyone else on the main motion? Senator Castro, you are recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in support of the measure. I think we've seen the debate throughout this term and even in the prior term whether we should authorize extended leases or authorizations for an entity for the use of public properties or public assets. This is a fine example of how we can see the upside of such an extended agreement. It's reasonable, and in my opinion, it's in conformance with most long-term financing opportunities, whether it's for the acquisition of federal grants, for the development of fixed assets, or acquisition of fixed assets, or construction of new buildings, and so forth. But again, I just found it important to state that for the record, as the 36 should convene in January and contemplate the principle of the extended lease, whether it's for a football association or for some other type of public benefit. Thank you, Madam Speaker.
Thank you, Senator Castro. Anyone else on the main motion? Senator Therese Terlahi, you are recognized.
Thank you, Madam Speaker. I'm looking at the committee report and at the bill and at the testimony, and all of it says that, you know, they need to have a minimum of 20 years. So I support the intent of this bill, but I'm noticing a disparity in the actual licenses that were granted in the past. So I could ask that we recess until tomorrow morning at 9. I would like to clarify that with the sponsor. Right.
We'll take a moment's recess. We are back from recess. Speaker Munya Barnes, you are recognized.
Thank you, Speaker. Just based on that, Madam Speaker, I don't mind if we just move to set the bill aside and work closely with one of our colleagues in reference to the concern they had on the lease and other provisions to strengthen this bill. So if we can just momentarily set this bill aside, maybe deal with the next bill, and then we can come back to this first thing tomorrow morning.
Thank you. On the motion to set the bill aside for the moment, any objections?
No objections.
Well, we are now on Bill 304-35 COR. Senator Munya, you are recognized.
Thank you, Madam Speaker. I move to place Bill number 304-35 COR, introduced by myself, Louise B. Munya, which is an act to add a new Article 26 to Part 2, Chapter 12, Title 10, Guam Code Annotated, relative to authorizing access to and use of experimental treatments for patients with an advanced illness, to establish conditions for use of experimental treatment, to prohibit sanctions of healthcare providers solely for recommending or providing experimental treatment, to clarify duties of a health insurer with regard to experimental treatment authorized under this act, to prohibit certain actions by public officials, employees, and agents, and to restrict certain causes of action arising from experimental treatment. This act is known as the Right to Try Act. I move to place this into the third reading, and I'd like to discuss it, Madam Speaker.
Thank you. You may proceed, Senator Munya.
Thank you so much, Madam Speaker. If Bill number 304-35 becomes law, Guam will join 41 states to enact a right to try law. On May 30th, 2018, President Donald Trump signed S-204 into law, which enacted the Federal Right to Try Act. This bill will preserve right to try in the event the federal law is repealed. Now, unlike the federal law, this bill followed the path of the states which adopted model legislation created by the Goldwater Institute. It's a charitable organization created by the late Arizona Senator Barry Goldwater. It was his intent to make drugs that were undergoing clinical trials available to those with cancer, Alzheimer's, and other terminal illnesses. This bill provides basic liability protection for doctors and drug companies whose medications or treatments have passed Stage 1 clinical trials. Stage 1 is the FDA approval stage where the safety of the drug or treatment is evaluated. Like the federal law, this bill does not require that these experimental drugs be provided for free or that doctors have provided their services for free. It simply allows a drug to be used prior to full FDA approval. Unlike the federal law, the immunities of this bill are extended to the pharmaceutical companies, but not their suppliers or subcontractors. There is some concern that the Right to Try Act might be repealed by the next Congress. The coronavirus pandemic has made us all acutely aware of the importance of new drugs to prevent and treat COVID-19. I remind this body that cancer, diabetes, stroke, and heart disease continue to claim far more lives. This bill offers hope to terminally ill patients that are told there is no more hope. Now, unlike the emergency use access, which are now most COVID patients are getting access to non-FDA approved drugs, and compassionate use access for those who have tried most forms of approved drugs that are not terminally ill, Right to Try is limited only to terminally or gravely ill patients. Madam Speaker, I welcome the discussion on this bill and hope that I can get the support from my colleagues. Thank you, Madam Speaker.
Thank you, Senator Munya. Is there anyone wishing to speak on the main motion? The main motion. No one wishing to speak on the main motion. Senator Munya, you're invited to close.
Thank you, Madam Speaker. And I just take it that either everyone's tired or the bill is very explanatory and self-explanatory. So I hope that, throughout this, if there are any other questions, definitely welcome to discuss it. But I do hope that my colleagues can support this measure, as this would allow our terminally ill patients to at least have a little bit of hope. Thank you very much, Madam Speaker. And I move to place this into the third reading voting file.
On the motion to place in the third reading voting file?
No
Any
objection.
objections? Motion passes. We are now on Bill number 368-35. Speaker Tina Munoz Barnes, you are recognized.
Thank you, Speaker. Madam Speaker, if I may, I'd like to move to recess to 9 o'clock tomorrow morning. At this time, both Bill 402 and 368 are mine, and I'd like to just make sure that we address the concerns of the previous bill and then the one coming up. So on a motion to recess at 9.
On the motion to recess till 9 a.m., we are in recess.